Section 497 was there since 1860 and it continued without any progressive amendment. What did it envisage? Essentially, that the husband of a wife who had an illicit sexual relationship with a man could go to court and ask that male paramour of his wife to be punished for adultery. It also said that if it was with the consent or connivance of the husband, then it did not amount to adultery. Here the husband had a right to go to court if he was aggrieved because of the male paramour of the wife, but the wife did not have a similar right if the husband was cheating on her with another woman and had sexual relationship with her. Secondly, the wife was being treated here as a commodity, as a property. And so the provision has been drafted such that if the husband consented to the wife having a sexual intercourse with another man, then it did not constitute adultery. However, if he did not consent, then it could be adultery. So deeming thereby that the woman in herself did not have any say or an identity of her own. Thirdly, section gets attracted only when it is the wife of the husband and not in case there is a relationship, a widow or woman who is not married. So those women are not taken into account in this particular section. It is only the wife. Again, commodifying the entity of wife. So this is reducing her dignity and it is discriminatory also at the same time. Whether a married woman having an illicit relationship or sexual intercourse with an unmarried man, it will not matter, because as long as she is married to the man who is aggrieved because of her having sexual relationship and intercourse with another man, whether that man being married, unmarried, it doesn't matter. It would constitute adultery. It would have constituted adultery in the section 497 that is no longer there. The court felt that adultery or the relationship between a woman with another man, a sexual relationship between them, should not be something where the courts and the states should interfere, because the court felt that it is a private matter and it would be an intrusion by the state or the court to actually interfere in a matter such as this. Though it did mention that it could be a ground for dissolution of marriage, I don't think that removal of section 497 should have an adverse impact on the society per se, because institution of marriage in itself should be based on trust, faith, and a lot of other things. So penal provisions like this to enforce and to put behind bars the paramour of the woman, a male paramour of the woman, I don't think are required to save marriages.